All right, hello and welcome. If you're a law student getting ready for your jurisprudence exams, then you're in exactly the right place. We're going to take the pretty complex concept of legal rights and break it down into a clear, structured format that's perfect for your exams. So let's get right into it. So here's our game plan for today. We're going to start with the absolute basics, the definitions from the key jurists you need to know. Then we'll deconstruct a right into its 5 essential pieces. After that, we'll dive into the big philosophical debate, the will versus interest theory. Next, we'll classify the different types of rights, and then tackle Hohfeld's more advanced analysis. And most importantly, we'll wrap it all up with a practical framework you can use for your exam answers. Okay, first things first. To build a really strong exam answer, you have to start with a precise definition. The idea of a legal right is, the bedrock of any legal system. So let's see how some of the most important legal thinkers have defined it. A great place to start, and a name you should definitely have in your answer, is Salmond. His definition is a classic. He says a right is an interest that's both recognized and protected. Now, the key phrase here is rule of right. What does that actually mean? Well, Salmond clarifies that it means a rule the courts will actually enforce. So a legal right isn't just some moral idea. It's an interest that the law will stand up and defend for you.
Next up, we've got the German jurist Ihering, and his definition is beautifully simple: legally protected interests. You see how he puts the concept of interest, some aspect of a person's well-being, right at the very heart of the definition? Here, the focus isn't so much on your choice, but on the benefit you receive. And this idea? It's the foundation of what's called the interest theory, which we'll get into in just a bit.
And for a different angle, let's look at Holland. He sees a right as a capacity to control what other people do, all backed by the power of the state. This definition really emphasizes individual will and freedom, the power to make other people either do something or not do something. And this perspective is the cornerstone of the other major theory, the will theory. Okay, so now that we've got our foundational definitions locked in, let's break a right down into its component parts. According to Salmond, every single legal right can be pulled apart into 5 essential elements. And trust me, understanding these is absolutely key for a deep analysis. So let's make this real with an example. Imagine you purchase a piece of land. Number 1, the subject, or person of adherence, that's you, the new owner. You hold the right. Number 2, the person bound, or person of incidence. That's basically everyone else in the world who now has a duty not to trespass on your land. 3, the content of the right. This is an act of forbearance. Everyone else has to refrain from interfering with your land. 4, the object. Well, that's the land itself. And finally, number 5, the title. This is the sale deed, the legal event that officially gave you the right. Every complete legal right has these 5 parts.
Now we get to move from the what to the why. Why do we even have rights? What's their ultimate purpose in a legal system? Well, jurisprudence gives us 2 major philosophical explanations: the will theory and the interest theory.
At its core, this whole debate is pretty simple. The will theory, which is sometimes called the choice theory, says the whole point of a right is to give you control over someone else's duty. It's about your choice, your power. But the interest theory, or benefit theory, argues that a right's purpose is to protect your interests, your well-being. It's about what benefits you, even if you can't actively make a choice.
This slide really lays out the comparison for you. On one side, the will theory, championed by thinkers like H.L.A. Hart, basically says a right is pointless if the holder can't choose to enforce it or even waive it. But its biggest weakness, its key criticism, is that it seems to exclude people who can't exercise will, like infants or someone in a coma. On the other side, you've got the interest theory, backed by jurists like Bentham and Ihering. It justifies a right because it protects something vital to our well-being. It's more inclusive, for sure, but its weakness is that the idea of an interest can be a bit vague, like which interests are important enough to get legal protection. A good exam answer really needs to talk about both of these theories.
Okay, moving on from the heavy theory to something a bit more practical. Let's look at how rights are actually classified. You see, lawyers don't just work with abstract concepts. They deal with specific categories of rights. So let's go over the most important classifications you'll encounter. So the first distinction is really straightforward. Can you enforce it in court? A perfect right is one a court will absolutely enforce, like your right to get paid under a valid contract. An imperfect right, on the other hand, is one that the law recognizes exists, but for some reason you can't enforce it. The classic example here is a debt that's become time-barred by the statute of limitations. The right to the money is still there in theory, but you've lost the legal power to sue for it. This classification all depends on what the other person has to do or not do. A positive right requires someone to actively do something for you. For instance, your right to receive payment for something you sold means the buyer has to perform an act, paying you. A negative right is the opposite. It requires others to refrain from doing something. Your right to not be defamed corresponds to a duty on everyone else to not say false, damaging things about you. Now, this one is a fundamental distinction in law. A right in rem is a right you hold against the entire world. Your ownership of a house is a right in rem. Literally everyone has a duty not to interfere with it. A right in personam, however, is a right you hold against a specific person. If you and I have a contract, your right to my performance is in personam. It only applies to me. As a general rule, rights in rem are negative, while rights in personam can be either positive or negative.
All right, let's get into a more advanced topic. The American jurist Wesley Hohfeld argued that lawyers and judges use the word right way too loosely, and it causes a lot of confusion. He believed it wasn't just one single concept, but more of an umbrella term for several very distinct legal relationships.
So Hohfeld asked this exact question. He wanted to build a kind of analytical toolkit to bring some real precision to legal language. He wanted to figure out what are the fundamental building blocks of all our legal relationships. And this slide shows his brilliant scheme. He organized 8 legal concepts into 2 types of pairs. First, you have what he called Jural correlatives, which are the vertical arrows. Think of these as 2 sides of the same coin. If person A has a right, then person B must have a corresponding duty. Second, you have jural opposites, which are shown by the diagonal lines. These are mutually exclusive. If you have a privilege to do something, you cannot possibly have a duty not to do it. Let's quickly walk through this because it really clarifies things. In Hohfeld's very strict sense, a right or a claim in person A always corresponds to a duty in person B. Makes sense. Now, a privilege or liberty in person A corresponds to a no right in B, meaning B has no legal basis to stop A. A power in A corresponds to a liability in B, meaning A can change B's legal situation, like making a contract offer. And finally, an immunity in A corresponds to a disability in B, meaning B simply lacks the ability to change A's legal status. It's a framework that brings incredible clarity to legal thinking.
Wow. Okay, we've covered a lot of ground. So now, let's put it all together. Let's create a practical, step-by-step guide on how you can structure all this information into a high-scoring university exam answer.
Think of this slide as your roadmap for a 15-mark question. You start with your introduction, nail those definitions from jurists like Salmond, Ihering, and Holland. Then, for the main body, think how, why, and which. First, how is a right structured? That's Salmond's 5 elements. Second, why do rights exist? That's your discussion of the will and interest theories. And third, which kinds of rights are there? That's where you bring in the classifications. And for a truly top-tier answer, maybe add a paragraph on Hohfeld's analysis. Finally, conclude by summing it all up. This framework ensures your answer is comprehensive, logical, and hits all the key marks.
And to leave you with one final thought, the concept of legal rights isn't set in stone. It's always evolving with society. If rights are really about protecting interests, what are the new interests that are emerging? Things like the right to digital privacy, maybe a right to a clean environment, or even the rights of AI? It's a question that shows just how relevant jurisprudence still is today. That's all for this explainer. Good luck with your exams.